see him? He's coming. He's there. He's dressed in a black suit. Black suit? Could be blue.
What a crock of
You know what? Patrick Swayze's right. What a crock. And he could be talking about a Manhattan fortune teller who's accused of bilking a client out of, get this, more than $700,000. Police say the medium promised she would help him get reunited with a woman he loved. And to do that, she needed lots and lots of money to get the spirits to talk to her. She also needed a $40,000 diamond ring to help the process along. And let's not forget about the $30,000 gold Rolex. But
what about the $80,000 gold bridge?
Even the
unlimited devotion.
Even the ring and watch didn't work. Thank you, Mark. The woman he was trying to reach died. The fortune teller promised to reincarnate her. Apparently, she wasn't able to do that. The client then called the cops. The fortune teller is now facing grand larceny charges. Okay, this is another one of these cases where I'm not defending the fortune teller.
I am.
Because
P.T. Barnum would defend the fortune teller.
If we assume, can we all stipulate that nobody can predict the future? Can we stipulate that? Can we all in agreement of that?
I see a Stanley Cup in red in your future and a World Series trophy in blue.
I've heard that one before. You're not getting $1 out of me for that. But
here's my watch, Mark.
So if the whole thing from a factual standpoint is something of a scam, since nobody can predict the future, at what threshold does this become a crime, Jim?
It's mind-boggling. It's under the law, it's got to be larceny by false pretenses. It has to be a misrepresentation that is reasonably relied upon. How could
that true? Is there a reasonable? Now that's serious. In all seriousness, is it like a civil fraud statute where there has to be a reasonable reliance upon?
It's got to be relied upon in order to deprive the person of property.
That's part of the grand larceny statute.
Absolutely.
Reasonable reliance. I doubt
reliance. No, it's got to be a misrepresentation relied upon. I'm saying, can it possibly be relied upon?
Yes,
when this
it can be relied upon if the reliance doesn't have to be objectively reasonable.
By that standard, isn't any fortune teller illegal or violating the law?
Yes,
Yet there are fortune teller places all over the city.
My thing about this, if I were defending the case, shared suspension of reality is an integral part of the fortune-telling experience. Not to sound too pompous about it. You go into the psychic medium with a suspension of disbelief. She's telling them exactly what they want to hear. How could she have possibly gotten him to pay? I mean, maybe he's absolutely insane, but you take your victim with the eggshell skull. Nobody in there, right? And he's in advertising. Do you think Don Draper would have forked over the $720,000? He's selling the same snake oil as an advertiser that she is, and he paid for it.
But Mayo, then is it that it's $700,000, or wouldn't it be larceny or fraud in this case if it was $1?
Well, arguably it would be, but then again, you have to look at what was his expectation. What would a reasonable person think was going to happen here?
It was therapeutic, was his expectation.
That's right, but look at what
it's
the
almost
statute...
an entertainment value.
Yes, it
here.
is.
Look at what the statute says. The false pretense must be the means by which the defendant obtains the property. The owner must rely upon it in parting with the property. Obviously, if the owner knows the pretense or token was false, he could not have relied upon it.
Who's saying that? One of the commentary to the practice commentary?
It's a criminal jury instructions.
Right.
So that's where my point comes in about it being reasonable. I mean, he can say, I relied upon it, but as Mark says, if you're going there for therapeutic purposes, who doesn't know that she doesn't have a time machine, that a gold bridge is somehow not going to reincarnate somebody?
See, in a federal fraud case, there is no requirement of reasonable reliance. In a civil fraud case, there is, but the representation in a fraud case has to be a material one. So it's a backdoor way of saying there has to be reasonable reliance. If that's what the jury instruction is, it makes the prosecution completely ludicrous.
So why isn't this fraud instead of larceny?
It ought to be civil.
He should be suing her as opposed to her being arrested.
And even then, you have to wonder, I mean, what did you think was going to happen
I'm not sure
here?
that there's a straight-up criminal fraud statute in New York that would cover this sort of behavior. It's not like not to get too technical, it's not like a Martin charge. And I mean, I guess fortune telling is some sort of business. Some villages up here outlaw fortune telling, period.
Right.
So maybe you have to be a licensed fortune teller? I don't know.
But that's local code.
Is that local code?
She get that, a licensed fortune teller.
I don't know, the state
So
licenses it, so maybe
she's to steal.
She's telling you get a license, but not to steal like this. Maybe they should regulate.
She clearly had his consent.
Yeah,
He consented
it's
to all of
ludicrous.
this.
It's ludicrous.
And the argument that he might have been deceived in this process,
How did
can't
this
you make
man
the argument
amass
that he was deceived?
$720,000 to give to a fortune teller? How did he? Why don't I have
What
that?
she should have done was she should have taken a page from the pharmaceuticals and said side effects may include loss of all of your money and not
He
getting
enjoyed
back
it.
together
He
with
had to
your
have enjoyed
wife.
it because it gave him hope, and he paid for hope. Is what he paid for.
What about the argument that this is all entertainment and that he should
is
have known this
entertainment.
going in, and so he just paid a very hearty bill for a
He
lot of
went to see a
entertainment?
prostitute, but without having sex. That's what it was. He was feeling bad. He went to see somebody who saw him as a quasi-therapist. It went on for well over a year.
Yeah.
I mean, so this was a relationship of some sort, and value was given to him, and he did it with his eyes open.
What about my entertainment defense? That he should have known that this was all for entertainment because nobody can predict the future, as you said. Nobody can look into the crystal ball, so he should have known.
Well, whether it's for entertainment purposes or therapeutic purposes, it all comes back to the same thing. He absolutely had to know that what she was promising was not true.
You mean
was
the Golden
impossible.
Bridge to unlimited devotion
I don't know
for
about the Golden
$80,000?
Bridge. I don't
There was a
know-
Golden
I'm
Bridge.
talking about the time machine. No, the Golden Bridge is okay.
If the phone rings and it's the fortune teller, do you take her case?
No, because she probably squandered the $720,000.
If she's got the
Oh, so
700,000.
if she's got the money, do you
course I
take
would
the
take the
case?
case. She's
First, I
innocent.
consult with her to see if we're going to win.
She's innocent. What did she
You're
do?
only going to take it. Jim, do you take the case?
Yes, I did.
All right.
Of course I did.
Okay, you said from the ridiculous to the sublime earlier. Here we go. Here's another doozy. A Virginia anesthesiologist,
these?
it's just reading the newspaper.
Rich wouldn't do
An
this.
anesthesiologist
These are
just lost a
great.
$500,000 defamation and malpractice lawsuit after she and her team were caught on tape slamming the patient. Here's a sample.
Really, after 5 minutes of talking to you in pre-op, I wanted to punch you in the face and man you up a little bit. So just make sure you're gowned up.
Give me some lube on the phone.
I don't want you to accidentally rub up against it. Some syphilis on your arm or something.
It got worse from there, but we can't play it for you. This is a family program. The patient says he taped the conversation with the doctor so he could play back the instructions, but he accidentally left it rolling the whole time and heard all of their conversations while he was knocked out. Malpractice as part of this? How does what didn't seem like they did faulty work?
Well, they did because they wrote false diagnoses on his chart. So the malpractice is actually much more reasonable than the defamation, because my understanding of the defamation law is that someone would have to interpret these statements as factual in nature, when clearly they were just trashing the guy.
And you need publication also. So if
Well,
you
it
don't
was
have
published to the other people in the room.
3 people, but those 2 or 3 people, that's your damages are going to be limited by the publication.
Well, he
there,
got
and it's pretty small.
$500,000 because of punitive damage.
That's going to be appealed, though.
So if I fall asleep and the 3 of you start talking about me, and I'm not saying that this is what should happen, I can be defamed just because you're talking
It's
about me?
ridiculous.
It's not,
No, it's
we're not
ridiculous.
assuming
They just
TV
didn't
cameras
like
aren't
the
there.
behavior, and they slapped the doctors.
That's
with it.
exactly what happened. I mean, Mark is right. The malpractice is actually more viable because of the misdiagnosis that's recorded. The making fun under the statute probably is not defamation. It's just really in bad taste.
And it's an intentional misrepresentation regarding the person's possible health consequences.
Absolutely.
So you're going to have other doctors that are going to be treating this person down the road, and they're going to take into consideration, did he have hemorrhoids? And that may lead them to a diagnosis that's inappropriate and could lead to treatment that's detrimental.
I mean, they're talking about the coarse language, and it's very, very salty, obviously. It's highly entertaining, but that's not the real problem. The stuff that's more serious, and this is writing false things on somebody's medical records. That's
Even though
serious
it didn't
business.
necessarily impact the
Who
outcome.
knows what it would impact? I mean,
Well,
they're
it
just
didn't
making up
impact-
false diagnoses, things that he had, and writing them on the record.
It didn't impact the outcome of that.
this
And you
colonoscopy.
know, look, we don't know
Which is what it was,
necessarily.
colonoscopy.
There could be a perforation that occurred during that colonoscopy because they're goofing around and he may not be aware of it until later something happens. So sometimes you are impacted by them not taking it seriously and paying attention to what they're supposed to be doing, but certainly down the road it could have a consequence to this patient.
Well, there's no indication that they did the colonoscopy wrong.
No,
It's
no,
just-
not in
That's-
this,
and I
not in
guess
this case.
I guess
but
that
it-
was my
you know.
question on the malpractice end, that even though the procedure ended with the patient in good health, he wasn't injured by it, they're still guilty of malpractice?
Again,
Because of the records.
inserting false diagnoses onto somebody's medical records, which follow them from one doctor to another doctor and so on and so forth, that is your basis for the malpractice. I do not believe that the making fun really has any
If they
root
spent a
in
day in my
malpractice.
office and heard the thing that goes on there, my God, I got to think twice. I got to debug the office now. I got to go through all of this.
Leave your
we
phones
know some of
outside.
your clients. So what happens from here? It sounds like there's probably an appeal?
Of course.
Yeah, absolutely.
And with reasonable grounds?
Sure, because you're going to look at the proportionality of the award to any damages. And if it's been rectified, so chances are there are not going to be any additional damages going forward. Although the $500,000 is not
Punitive damages.
it's
I think
not
the damages
extremely
will be
unreasonable
the damages
given
will be
the medical
sustained.
malpractice. And
I think they'll be
From a
sustained.
punitive nature,
Yeah.
but not from a compensatory
I think they'll
nature.
strike out the defamation claim because no reasonable jury could have found that anybody would have thought that these were factual statements. Sustain the damage award because it's not that outrageous.
Well, here's the other issue, though, is that the jurors spoke afterwards. And a lot of the jurors said that they felt they had to give the guy something. So those are some things that you actually use on the defense to try to reduce what the award was.
Very quickly, not that it's a legal issue, could the doctors lose their licenses as a result of that, and would that impact an appeal?
Yeah, I think that they already, according to the articles I read, people are already checking around. So far, no disciplinary action has been imposed. Their licenses are valid. The woman, the anesthesiologist, apparently moved to Florida, which is where every malefactor goes. Just go to Florida, we'll look for him in the Everglades, and nobody could find her. Maybe these people broke out a prisoner in Florida somewhere.
Mark, Mayo, Jim, absolute pleasure for a chance to host the legal panel. Thank you for going easy on me as the case may have been tonight. We'll be right back with your Hudson Valley headlines next.